published in the Duke Law Journal and Harvard Journal on Legislation, among other places. He's a contributing editor for the Lawfare blog and previously served in the Office of Legal Counsel, giving him also practical experience. And then afterwards as Assistant Solicitor General for the state of Tennessee. He clerked for the Fourth Circuit and served as a Bristol Fellow in the U.S. Solicitor General's office. Professor Mascott, I'm jumping the queue here, is Assistant Professor of Law and Co-Executive Director of the C. Boyd and Gray Center for the Study of State at the Antonin Scalia Law School of George Mason University. Let me put quotation marks around administrative state for my own editorial intervention. She previously also served within the Department of Justice in the Office of Legal Counsel and as an Associate Deputy Attorney General. And finally, Mark Rozelle is the Dean of the Schar School of Policy and Government at George Mason University, where he holds the Ruth and John Hazel Faculty Chair in Public Policy and is the author of the book Executive Privilege, Presidential Power, Secrecy, and Accountability. Thank you for your willingness to help us work through these issues and find common cause going forward. And I turn it over now to my colleague and friend, our ranking member, Senator Kennedy.
Thank you, Mr. Chairman. Our chairman has raised some very interesting questions on a subject that I think we're all interested in. I came today to try to learn. Based on the credentials of this panel, I think I'll learn a lot. I want to thank you for coming. I'm going to stay as long as I possibly can. Please tell us what we need to hear. Tell us what's working, but I'd also like to know what's not working and what you think we should do to fix it. And again, thanks to our chairman.
And let me thank Senator Hirono for joining us and recognize that she is present and invite the witnesses to give their statements for 5 minutes apiece, if you don't mind. Professor Shaw.
Great. Chairman Whitehouse, Ranking Member Kennedy, and distinguished members of the subcommittee, thank you for the invitation to testify today. My name is Kate Shaw. I'm a professor at Cardozo Law School, and as the chairman said, before I began teaching, I served as a lawyer in the White House counsel's office from 2009 to 2011. So I understand that the purpose of today's hearing is to evaluate the current process for resolving conflicts between executive privilege and congressional oversight. I will start by saying that my view as a scholar and a former White House lawyer who believes both in a constitutionally grounded executive privilege and in the importance of robust congressional oversight is that the current process is very much in need of reform. In recent years, longstanding norms of interbranch cooperation and accommodation have largely broken down, and Congress has been denied meaningful access to much executive branch information. This development is a worrying one from the perspective of executive branch accountability and general separation of powers principles. My written testimony provides background on executive privilege, both generally and in the context of congressional oversight. So in the interest of time, I'll just say that the judicial authority in this area forms the backdrop against which disputes between the political branches play out. On the substance, it is relatively favorable to Congress, but in every major recent dispute that has ended up in court, the judicial opinion has come too late to have much impact at all. And as important as the case law is, equally or more important is the authority from the political branches, in particular the numerous written opinions and directives from presidents and senior DOJ officials that have guided the executive branch's approach to these issues for many years. Taken together, these documents reflect a strong vision of executive privilege, a power which the executive branch understands to have constitutional foundations to keep certain information confidential, but they also reflect a recognition of Congress's authority to access some executive branch information. Guided by the need to respect these two competing principles, the executive branch has, in countless inquiries over the years, worked with Congress to grant some information access while withholding documents the executive branch believes warrant protection in keeping with the basic purposes of executive privilege. In the view of the executive branch, those purposes are largely, though not exclusively, about protecting the president's decisional processes. As the Supreme Court explained in United States versus Nixon, a president and those who assist him must be free to explore alternatives in the process of shaping policies and making decisions, and to do so in a way many would be unwilling to express except privately. So this cooperative give and take has largely broken down in recent years. I will highlight just a few developments and then briefly touch on several possible reforms. So the first novel development is the emergence of protective or prophylactic assertions or mere suggestions of executive privilege, whereby witnesses appear to testify but refuse to answer specific questions on the grounds that the president might later assert executive privilege, or where executive branch officials refuse to provide any documents or testimony on the grounds that some of what is sought might later be subject to a privilege assertion. The second related development is the outright refusal to cooperate in any way in particular investigations. And the third is rooted in longstanding executive branch positions that close presidential advisors enjoy absolute immunity from compelled testimony, but the most recent administration took an exceptionally broad view of that immunity. So briefly, what reforms would I recommend? First, internal executive branch reforms. The executive branch's increasing tendency to invoke just broad and undifferentiated confidentiality interests should yield to a requirement that assertions of executive privilege be made only upon a detailed description of the specific executive branch interest that would be threatened by the production of documents or testimony. Second, the executive branch could refine and formalize its approach to documents or testimony that contain evidence of wrongdoing or misconduct. Lawyers within the executive branch have generally adhered to a strong norm in which documents or testimony that would reveal wrongdoing are not viewed as candidates for an assertion of the executive privilege, but it's not clear that that principle has held in recent years, so the practice needs to be strengthened and perhaps formalized. Since I'm running out of time, I'll touch briefly on two more matters. One, congressional practice. It's important that congressional committees engaging in oversight work to ensure that their requests for information or testimony are reasonable and not overbroad. In addition, committees should work to minimize the extent to which their requests duplicate or overlap other requests. The executive branch, as those of us on this panel have worked there know well, is actually pretty leanly staffed, in particular the Office of Legal Counsel. So requests that seek enormous volumes of documents that require time-consuming review by lawyers are unrealistic and frankly unreasonable. And finally, as the chairman alluded to in his opening, on courts, my view is that it would be better for most or all of these disputes to be resolved out of court, but if they are going to be resolved in court, it would be well advised to consider legislation that would expedite judicial resolution. I see my time has expired. Thank you so much for the invitation, and I look forward to your questions.
Thanks, Professor Shaw. Professor Schaub.
Chairman Whitehouse, Ranking Member Kennedy, and distinguished members of the committee, thank you for the invitation to appear and talk about two subjects dear to my heart, congressional oversight and executive privilege. And I am honored to be part of this esteemed panel and look forward to the discussion. Congress's authority to conduct oversight and the executive branch's authority to withhold information are both implicit constitutional authorities. Neither appears in the text of the Constitution. Accordingly, the scope of executive privilege has been, as you know, the subject of considerable controversy and dispute. In individual oversight disputes, this constitutional ambiguity has historically been resolved outside the courts through negotiation and compromise, known as the accommodation process. The back and forth negotiation between Congress and the executive branch over access to information has been called a dance because it's a flexible, ever-evolving process governed as much by normative and historical practice as well as current politics as by legal principles. But normative practice fades easily in the context of the intense partisan battles that have lately come to characterize oversight. And in such disputes, the executive branch's views ultimately govern because the executive branch holds the information. As later Chief Justice William Rehnquist explained when he was the head of OLC, the executive branch has a head start in any controversy with the legislative branch. Since the legislative branch wants something the executive branch has, and therefore the initiative lies with the former. All the executive has to do is maintain the status quo, and he prevails. Given that head start and the lack of applicable judicial authority, the executive branch's internal constitutional doctrine is the primary source of legal authority that governs its responses to congressional oversight. In my view, that comprehensive doctrine, put into practice, has led over time to an imbalance in congressional oversight. By relying on its view of executive privilege, as well as a series of prophylactic doctrines deemed constitutionally necessary to protect executive privilege, the executive branch now has the tools to stymie any congressional oversight it so chooses. So understanding this internal executive branch doctrine is vital to understanding the state of oversight. My written testimony describes these principles in detail, principles that I helped put into practice while I was working at OLC. I have since studied and written about these principles and their historical development. And although often unstated, these constitutional principles inform almost every aspect of the accommodation process that occurs between the branches today. Scholars and commentators have called on Congress to act aggressively and urged it to deploy various constitutional tools to attempt to rectify the current imbalance and force the executive branch's hand. My view, however, is that none of Congress's current tools are effective if the executive branch decides to play constitutional hardball, which it has done with increasing frequency. In short, in current practice, the executive branch has essentially unchecked authority to withhold any piece of information it chooses from Congress. I would like to note at the outset that I believe this fundamental disagreement between the branches that has led to the current imbalance is an institutional disagreement, not necessarily a partisan one. Although oversight disputes often become embroiled in partisan politics, oversight related to the Operation Fast and Furious during the Obama administration or the Mueller report during the Trump administration are two recent examples, the foundations of the doctrine on which the executive branch relies to withhold information and testimony are bipartisan, both in their creation and their execution. That is not to say that all oversight disputes are created equally. Some presidential claims of privilege or related doctrines, such as immunity, are more extreme and have substantially less historical support than others, and as a result warrant criticism and controversy. But they share a common wellspring, a comprehensive constitutional doctrine developed almost wholly within the executive branch that elevates the executive branch's institutional interests over Congress's. I do not suggest that this doctrine has been developed in bad faith, and few would argue with the proposition that the executive branch has real confidentiality interests that warrant consideration. But these internal constitutional tenets equip executive branch actors with powerful weapons that are difficult to resist deploying during these disputes. Whether this current imbalance is a problem in need of reform or an appropriate mechanism for protecting executive branch confidentiality interest is a matter of debate, of course. But if reform is the goal, my view is that the necessary first step in rebalancing the branch's respective authorities is judicial resolution of the fundamental constitutional oversight questions at the heart of the disagreement between the branches. Judicial resolution of individual disputes has proven ineffective due to the length of time necessary and the appeals. But judicial consideration and resolution of antecedent constitutional questions has proven vital and necessary in the past when claims of absolute constitutional authority have inhibited the resolution of interbranch disputes. Precedential appellate decisions on these issues have proven elusive, and Congress has at times chosen not to pursue its institutional interest in seeking such precedent. So if reform is the goal, congressional action should be directed to legislation that increases the likelihood and the availability of a judicial decision on the merits of executive privilege. Thank you.
Thank you, Professor. Mr. Rozelle.
Ranking Member Kennedy and Senator Hirono, thank you for the invitation to testify. I have submitted for the record a detailed version of my testimony that is based on my past and ongoing research on executive privilege, and here would like to focus on the accommodation process. Among scholars, there's very little debate about the legitimacy of executive privilege as a principle, as this doctrine is well established in practice and in law. The focus of academic debates is the scope and limits of this power. It is widely recognized that presidents have occasional secrecy needs and that the right to withhold information and testimony from those with compulsory power also is not absolute, and that the power to compel disclosure, is not absolute. Like other constitutionally based powers, any claim of executive privilege is subject to a balancing test. Presidents and their advisors may require confidentiality, but Congress needs access to information from the executive branch to carry out its lawmaking, oversight, and investigative functions. Now, not all presidents have exercised executive privilege judiciously. Some have used it to cover up embarrassing or politically inconvenient information, or even outright wrongdoing. As with all other grants of authority, the power to do good things is also the power to do bad things. The only way to avoid the latter is to strip away the authority altogether and thereby eliminate the ability to do the former. Permanently constraining this executive power because of the actions of any current or former president would not, in my view, serve the national interest. At various times, there have been calls for legislative or judicial imposed restrictions on executive privilege, and here I disagree. It is impossible to determine in advance all the circumstances under which presidents may have to exercise that power. The resolution to executive privilege disputes is found, I believe, in the political ebb and flow of the separation of powers, not in the courts defining in advance the guardrails. Congress already has the institutional capability to challenge claims of executive privilege by means other than attaching statutory restrictions on the exercise of that power. For example, Congress may withhold support for the president's agenda or for the president's nominees for executive branch and judicial positions. In one case during the Nixon years, the Senate Judiciary Committee threatened not to confirm a cabinet nominee until the president dropped an executive privilege claim to prevent a White House staff member from testifying. Senator Sam Ervin even threatened to filibuster the nomination if it cleared the Senate. The Senate's pressure resulted in President Nixon withdrawing his privilege claim and allowing a White House aide to testify in person and to answer additional written questions from the committee. Similarly, members of the Senate Judiciary Committee in 1986 threatened not to confirm the nomination of William Rehnquist as Chief Justice of the United States Supreme Court until President Reagan dropped an executive privilege claim over documents from Rehnquist's tenure in the Department of Justice. And here, a bipartisan majority of the committee supported a subpoena of key documents, leading to the president eventually compromising and agreeing to allow the committee to access the selected categories of documents. If information can be withheld only for the most compelling reasons, it is reasonable for Congress to try to force the president's hand by making him weigh the importance of withholding the information against that of moving forward a nomination or a piece of legislation. Presumably, information being withheld for purposes of vital national security or constitutional concerns would take precedence for the president over pending legislation or a pending appointment. If not, then there appears to be little justification in the first place for withholding the information. Congress has many other tools as well. Control over the government's purse strings, the threat of cutting agency staff and funding is a powerful tool for sure. In addition, Congress has successfully used the subpoena power and contempt of Congress charge to compel the release of information. I cite numerous examples in my research where that has been very successful. Now, in an ideal world, all such issues would be resolved on the objective merits of the positions of the executive and the legislative branches. In reality, political considerations and public opinion play important, often determinative roles, as in most other interbranch disputes and negotiations. And again, I bring forth some examples to illustrate where that has worked in the past and where political considerations have been key in many of those cases. I believe Congress has the responsibility to consider the president's reasoning for an executive privilege claim. There are occasions when, after doing so, Congress has either given deference to the president's position or decided that the stakes involved were not worth an interbranch fight. In the vast majority of cases, and history verifies this point, it can be expected that the president will comply with requests for information rather than withstand retaliation from Congress. History is replete with many such examples. And if members of Congress believe that a particular exercise of privilege poses a threat to the constitutional balance of power, the answer resides not in crippling presidential authority, but exercising to full effect the vast array of tools at Congress's disposal. Thank you.
Thanks very much. Professor Mascott.
Chairman Whitehouse, Ranking Member Kennedy, and members of the subcommittee, good afternoon. Thanks for the invitation to appear today. Today I'll build on my prepared testimony by briefly unpacking the constitutional principles and history related to oversight and privilege, discussing practice across administrations, and addressing the path forward for Congress if it seeks more control over the substance of executive branch authority. First, is there a constitutional problem with executive and legislative disagreement over information disclosure? Are there roadblocks that need addressing, and if so, what are their scope? The constitutional system is designed to embody divided government, both a vertical division between state and federal government and the horizontal division among the three federal branches. Two of the branches, the political branches, have their own independent constituencies. So in contrast to the judiciary, the executive and legislature are directly accountable back to the American people. And these two branches, therefore, have a natural rivalry. They favor distinct institutional interests by design. Paraphrasing the well-known Federalist Paper number 51, the constitutional framers contrived the interior structure of the federal government so that its several parts, through their mutual and careful interactions, would be the means of keeping each other in their proper places, and so divided federal government, at times inefficient government that's slow and deliberate, has always been a key safeguard for individual rights. So when the executive and Congress disagree over information disclosure, it's not surprising. In a sense, those disagreements stem from a mutual and constitutionally intended interbranch back and forth. That said, all three branches have acknowledged that intractable conflict should be avoided wherever possible. And formal executive branch policy for decades has been to disclose as much as possible when Congress requests information related to its constitutional functions. The Supreme Court's repeatedly observed that congressional power to pose inquiries is broad and indispensable, but the courts also specify that information requests must be related to and in furtherance of a legitimate task. And so therefore, analysis of executive branch disclosure should start with the threshold jurisdictional question of whether an information request is incident to one of Congress's enumerated powers. In other words, is the request tailored to achieve a legitimate legislative purpose? Only then would any potential privilege claim come into play. The Constitution does not expressly discuss executive privilege or expressly grant any power of oversight or investigation, but modern doctrine grounds executive privilege in the constitutional need for executive branch confidentiality and candor in advice giving, and each branch has a measure of sovereignty over its deliberations and use of information to carry out its functions, such as the critical executive role in national security and foreign affairs. That said, as a practical matter, the executive branch often provides extensive information without asserting privilege, and in disputes, executive and legislative officials often resolve differences through the accommodation process, which has existed in some form since the first presidential administration. For example, after George Washington's objection to a House committee request in 1792, the House narrowed the request, and a few years later, Thomas Jefferson provided just a limited set of documents and summary of relevant events when Congress requested comprehensive records related to a possible conspiracy involving foreign affairs. So accommodation can involve negotiations over the scope of disclosure, but also its form, with the executive branch sometimes providing access to documents for a limited time period, for in-camera review, or through the provision of summaries of requested documents. There have been suggestions that recently the practice of executive privilege has significantly expanded, but I think in contrast, practice over multiple administrations has been by and large remarkably consistent. In 1982, the Department of Justice cataloged more than 60 instances spanning 27 administrations in which presidents had claimed executive privilege. Protective privilege assertions are not new, and past administrations of both political parties have asserted absolute testimonial immunity for certain senior presidential advisors. So then if Congress wants to assert its own institutional interest in exerting control over the substance of executive administration of law, what is the path forward? As some of my colleagues have suggested, Congress could pose narrower initial information requests, making even clearer on the face of requests their constitutional objective. Congress can exert control through appropriations or its role in consenting to nominations. Congress also could legislatively impose new affirmative reporting requirements, seeking data for potential legislation, which would relieve pressure on targeted oversight requests once controversies already arisen. But most fundamentally, Congress can alter its balance of power of the executive by more vigorously enacting specific substantive policy instructions on the front end through legislation. In addition to the use of oversight as a tool toward legislation, Congress has the power to directly alter the policy itself. And so congressional action will have the most bite when it legislatively cabins executive discretion and policymaking before that action ever takes place. Thank you.
Thank you very much. This has been a great panel. I carefully read each of the full testimonies that you all filed. And the first thing I was struck by is how much overlap there is amongst what you all had to say. And in particular, I just want to make sure that I'm correct on this. It seems to me that each one of you agrees that we should do something, that the present status quo, just left to its own devices, would be suboptimal, and that there are good steps that we could take to improve the engagement between the executive and legislative branches on discovery and privilege. Is that correct? Professor Shaw is saying yes. Professor Schaub, yes. Mr. Rozelle? Limited, but yes.
Yeah.
This is not an idle effort of ours, I guess.
It's not an idle effort.
And Professor Mascott?
Well, yes, but I would address it more through legislative on the front end rather than
Understood.
the oversight process.
And I think there's also pretty broad agreement that there's a broad, common, well-established understanding of the law of executive privilege. There course, concerns around the margins, but this is not an undeveloped area of law, nor one in which there is some massive conflict between one school and another. We actually have a pretty good substantive foundation to proceed from. Is that also commonly agreed? Professor Shaw's yes?
I'm not sure. I mean, I think there are really fundamental disagreements between what Congress views as executive privilege and what the executive branch. I mean, the amount of information that Congress views as protected by executive privilege is limited to presidential communications, and the executive branch has a number of components. And so I think there's a pretty wide disparity.
There's some wide definitional questions in there. Got it. Understood. Mr. Rozell?
Yeah, I agree. And even among scholars, although there is widespread agreement about the legitimacy of the principle of executive privilege, not everybody agrees on exactly what the scope and limits of that power is.
Yeah. Professor Mascott?
Yeah, I think historically the practice has been pretty consistent, yes.
And the actual procedure that one is expected to go through in a conflict over the production of information from the legislative branch seems to me to have been pretty well established by the Reagan memo, and I don't know that there's any different there may be people who have not complied with the Reagan memo, but it seems to me that that is the process foundation for us to begin our work in this committee. Would you agree with that?
Yes, I mean, I think that's right, that there's been pretty broad bipartisan adherence to that general kind of flow between the branches. Although, as I said in my opening, I think that their compliance with those general procedures was lacking in recent years.
We've seen some real breakdowns recently, and that's why we're having this hearing to try to see if we can find a way to steer through those breakdowns. One of the things that seems to be very important in this is OLC's role as an honest ombudsman, to help kind of be a bit of an honest broker for the executive branch with Congress. Is that important? And is that enforceable? If we could write something that said the OLC shall be an honest ombudsman, would that be enough? Professor Shaw?
You know, I'm not sure what it would do, quite honestly. I think that every administration has taken seriously.
In a different way, does the Reagan memo contemplate OLC having something of an ombudsman role?
Yes, I think so. And I think that every subsequent OLC has understood itself to have that role. But I think just as Professor Schaub suggested, the contours of the privilege and the obligations of each administration as understood by each Office of Legal Counsel, sort of has shifted to some degree. But I think OLC understands itself to serve that role. The larger executive branch understands OLC to serve that role. I mean, I think it's a question maybe for the committee how well OLC has discharged its obligations.
Of course, whatever they do, Congress has very little to say about, so it's unenforceable if they should depart from their role as an honest ombudsman. So that takes us to the general importance of good faith in this process, which I think everybody concedes is essential to it succeeding. 1, 2, 3, 4, yes. And then what happens if good faith breaks down? And that's where we get to where it gets interesting, to me anyway, and what judicial process should look like. And I'm a recovered lawyer, and I recall in cases where you had two contesting parties in a big case where they were really fighting with each other, and the way in which the court would handle that would be either to have the judge or the magistrate judge schedule status conferences and give every 30 days or 60 days the lawyers a chance to come in, yell at each other in front of the magistrate, explain why they're being treated unfairly, and have the magistrate judge say, look, I'm not making a ruling on this, but if this were to go to a ruling, you, sir, have a terrible argument, and you really look like you're going to win. So, take that as a guidance, and I'll see you in 30 days. And things would, tick along pretty well, and you end up cutting through a lot of the nonsense without having to wait through full decision and appeal. Do you think the status conference procedural mechanism, that kind of some kind of more constant but less final judicial intervention might be appropriate? And if that's too much to ask you in the time that I have, please take that as a question for the record, mull on it, bring your experience and expertise to bear, and give me an answer for what the judicial approval might look at.
I'm
like to hear that.
All right, we'll keep rolling then with the permission of the ranking member. Who wants to jump in on that? Professor Mascott, I see you reaching for your button.
Thank you. Well, I mean, I guess if the question is just generally judicial involvement, I mean, just as stepping back for a second, I mean, we've got the President's Supreme Court Reform Commission going on right now. I mean, it seems as though there are folks on all sides who have concerns about the amount of power that the judiciary has within the system. So it does seem curious that we would turn to the judiciary at this point to try to solve this particular problem. And also, you know, concerns, I mean, folks on both sides complaining about, you know, the role in sort of emergency proceedings. I mean, for there to be something done in a timely fashion, are we going to have more process on kind of the emergency docket? It just seems like an awful lot of power to give to the apolitical branch, and the court itself, I think, would be resistant to it, because in 2020, in the Mazars decision, it noted it had never before weighed in on an oversight decision. So I guess I just sort of step back and say, generally, it seems to me that the political process is working fairly well in this area. And is sort of functioning as it's supposed to, which sometimes is just going to have conflict, but often has.
Let me tell you where I disagree with you to
Yes, Senator.
react. And that is to Mr. Rozell's point about the political forces being brought to bear by Congress to push for a resolution. That's not something one senator does. That's something the entire body has to do. And I will assert to you all that there are innumerable inquiries that are made for information from the executive branch that never rise to that level of, what did Professor Rozell say, where the stakes are worth the fight of going up. But I do think that even if the stakes aren't worth the fight of getting an entire House of Congress engaged in trying to get information to a committee or a subcommittee or to a senator, there's still public value in a senator having some place to go, or a House member, or a subcommittee. And that's where I think some judicial intervention that is carefully limited so that it's really kind of like more like a status conference. Anyway, I've said enough. We can continue the conversation. I'm turning to Professor Kennedy. I get forgotten, I guess is my personal thing. I get forgotten if it takes the Speaker of the House or the Senate Majority Leader for me to get an answer. And there are dozens of senators like me whose concerns with not getting information are simply never going to rise to that level. Sorry, John.
No, very valid point. I mean, it has gotten worse. And I don't know whether the abuse of executive privilege tracks exactly the increase in partisanship in our country, but I bet it's close. I mean, it seems to me, and you folks would know better than I would, but because you've studied it, but inevitably there is going to be some friction, and there should be some friction. And I don't think our objective ought to be to make a good faith cat love a good faith dog. They're not supposed to under our separation of powers. But there's been a lot of bad faith, and I don't know whether the answer is to codify the so-called Reagan memorandum. You can't. I mean, you can say the OLC be a neutral arbiter, but you know, we live in a real world. I don't see any way to get a quick resolution without involving the judiciary. I just don't, as a practical matter. Now, should we have to? No. But we don't live in a perfect world. And I think that if you did have some sort of mechanism to get the judiciary involved, you would have a lot of people in both the legislative branch and the executive branch have an epiphany and say, maybe we ought to try to work these things out on our own. So I guess my question is, let's assume for a second and I could be wrong, okay? You could convince me that, as the professor said, maybe the worst thing we could do would be to involve the judiciary. My mind is open. But let's assume at some point we do have to involve the judiciary. How would you design that? It would have to be quick, and it would have to be accessible. You shouldn't have to get the majority leader or the minority leader's permission or the speaker's permission. For the BIPs like me, barely important persons, I'd like to be able to have access to do it too. But tell me how you design it, Professor Shaw.
Well, maybe I'll say in general that there may be a way between the sort of two paths that we are outlining, one of which is essentially to cede final authority over the resolution of these disputes to the judiciary, and the other which is to say the political branches just need to work it out on their own. Maybe a middle path is to design an expedited judicial resolution procedure that is rarely invoked because its very existence forces everyone to the table to actually resolve these disputes. So maybe it occasionally is invoked, but it is not.
Don't you think you'd have to invoke it a couple of times?
Sure, but hopefully that would be enough, and then you wouldn't. Sorry to interrupt, Senator, but yeah. So that maybe you do a couple of times, and then it is clear there will be, consequences for failure to negotiate in good faith and to reach reasonable accommodations. And I suppose it would just be whether a committee, a chair and a ranking member together, a single member of a committee. I guess I haven't thought carefully enough about who could initiate the process to speak really definitively about it here, but that would require, an expedited resolution, potentially the chairman's suggestion of 30-day status conferences until some kind of resolution is reached, and the fact of the process would serve a forcing mechanism. So, my general instinct is that the less judicial involvement, the better. I don't think either political branch should want to cede the ultimate authority over these important constitutional questions to the judiciary, and yet we do seem to be at a stalemate moment in which some third party may need to be pulled in.
I don't think the judiciary will like it, as the Professor Mascott said, but
I think that's right. Yeah, I don't think the courts would want this role, quite frankly. Political matters should be solved between the political branches. And there is a long history of an accommodation process between the legislative and the executive in which these disputes have been resolved by good faith negotiations and compromises over time. So
over time is the key
right.
expression.
And over time is okay, I would say. I don't see why there should be a rush to move things forward necessarily. Part of the separation of powers system means that things oftentimes have to move very deliberately and take their time, and that's quite natural to the process. And I don't think that there's anything wrong with that. So I don't see the courts wanting to get involved in this. I worry about what it says about the nature of the process, that some would believe that the courts need to step in and resolve what the legislative and executive can't do themselves.
I guess because we start from the proposition that this doctrine has been developed by courts, and that's how we are. Marbury v. Madison, what the law is. Senator Hirono.
Thank you, Mr. Chairman. I thought the role of the courts is to resolve constitutional disputes. So we're here because it would be nice if in situations where the executive invokes the executive privilege and the legislative branch disagrees, and so it would be nice if the accommodation process would indeed result in that way of resolving these kinds of conflict, but that's not what we've seen recently. So we're here because in those instances, there probably should be some sort of an expedited review process. Because I recall the situation relating to Don McGahn, where I think it took a year or something for the courts to tell us that he indeed should have to come to testify. I think that was the result. So Professor Mascott has said that, she cautions us from giving power to the apolitical branch. I mean, we can have a dispute about how apolitical the judiciary actually is, but let's assume that for the moment. And so, but that's one of the reasons that maybe in these conflict situations, we want the apolitical branch to help us figure it out. I kind of like the idea of the chairman's status conference situation. Those of us who have practiced law, we are familiar with the judge coming in or a magistrate bringing the parties together and saying, okay, you know, I've listened to both sides and here's what you should do. So, Professor Shaw, you indicate that maybe we should think about some sort of an expedited process. Could you elaborate on that a little bit more? For example, as a structural reform, what if we were to give exclusive original jurisdiction to challenge a subpoena to a 3-judge district court panel in the District of Columbia, say, under 28 U.S.C. Section 2284, which says that a district court of 3 judges shall be convened when otherwise required by an act of our Congress, so we could do such an act. That would expedite the proceedings.
Well, I think the Congress clearly has the constitutional authority to provide for such a procedure, and presumably there would be then direct appeal to the United States Supreme Court. I do continue to think that symbolically and practically there is something troubling about the political branches appearing to signal the superiority on matters of constitutional, debate and interpretation to the judiciary. Of course, Marbury versus Madison does tell us that the courts will say what the law is, but I think that the Congress and the executive branch have important roles in resolving disputed constitutional questions as well, and I worry that ceding too much power to the courts is a troubling development from the perspective of broader separation of powers concerns, or from the perspective of the kind of value of the separation of powers. If we assume that the bridge has been crossed, right, that's basically from the 1970s, the courts have been turned to as kind of arbiters of these disputes between Congress and the executive, and the question is just how better to design a judicial process so that we get to some final resolution that, again, serves as kind of an overhang so that most of these disputes can be resolved outside of the courts. I think that a 3-judge court mechanism with a mandatory appeal or a right of appeal to the Supreme Court is very much worth considering. And I'm not sure if you would legislate or, if you would sort of require a 30-day process in the legislation. I'm not aware of any 3-judge court with such a procedure, but I don't at least initially see any constitutional problems with requiring some such process. So if the bridge has been crossed, then I think that this is very much worth considering. I guess I would just raise a caution. Are there other mechanisms that should be considered in lieu of or in addition to focusing exclusively on the judiciary?
Do you see a status conference kind of a situation as a prelude to something more, such as a 3-judge panel?
I mean, I think that you could do them both, right? I think that the panel itself could conduct such conferences, and I think, to be fair, the district courts that have already overseen litigation around some of these privilege and oversight disputes, have been pretty active in trying to move the parties along. So I'm not sure this would be something wildly novel. It would just potentially kind of formalize the role, but I do think to a degree it is already happening.
Professor Shaw, do you have a comment?
Sure, yeah. I tend to take, I guess, more of a view that judicial intervention is necessary at this point. I mean, so we look at the foundational cases that. Sorry, so I take the view that I think judicial intervention has become necessary because of the place that we've arrived to as a matter of sort of constitutional law with the 2 branches, right? So you can negotiate in good faith, but if each of your good faith bases from which you start are wildly different, then you're never going to reach any sort of middle ground. And the way that executive privilege now is sort of practiced, in the Obama and Trump administration combined, there were 2 formal assertions of executive privilege. That was it. Despite all of the controversies and disputes, there were a couple of protective assertions, there were claims of immunity, but in terms of executive privilege itself, there were 2 formal assertions, and almost everything else occurred with these other doctrines that surround executive privilege and that give the executive branch sort of rationale to deny congressional oversight requests. Of course, Congress disputes those. Congress disputes that those exist, and they're the subject of controversy, and scholars have written about them. But there's no way to sort of statutorily fight them because the executive branch views them as constitutionally grounded principles. So you can pass a law and the executive branch says that's an unconstitutional law that won't be followed. The McGahn opinion about former White House counsel and other opinions say Congress cannot exercise even inherent contempt lawfully because it would be unconstitutional given the executive branch's constitutional doctrine. So I think there's a sort of fundamental constitutional disagreement that will not be resolved until there is a precedential appellate decision that forces the executive branch or Congress to sort of adjust its view and change the guardrails. And that's what happened in Nixon. And Nixon claimed an absolute right to privilege without any judicial review, and the Supreme Court rejected that. In the AT&T case, which is cited as the basis for the accommodation process, Congress claimed to be absolutely immune under the speech and debate clause. Ford and the executive branch claimed absolute executive privilege over national security, and the court said, before we can get to an accommodation, we have to address these claims of absolute constitutional authority first. So I think there needs to be a precedential opinion, and this is about these sort of fundamental constitutional disputes. And in the mine run of cases, I think you will eventually come to this where the sort of extrajudicial, or the status conference model, or whatever it might be, and you can resolve these disputes. But first, there needs to be some sort of fundamental constitutional principles on which both branches can start from to get to an agreement.
To be clear in my questions, I wasn't suggesting that whatever we should come up with by way of a judicial intervention should displace the accommodations process. Rather, it should provide guardrails to keep the accommodations process within some reasonable bounds. I'll give you an example. I've been looking at FBI tip line practices, and I asked the FBI 2 years ago, what's your policy for how you run a tip line? No answer. Lindsey Graham heard me bother them enough that he actually got the Deputy Attorney General up in his office to say, what the hell? Could you please answer these questions? This is presumably public information. And in fact, ultimately, by doing a search on the internet, we found a YouTube in which the FBI explained its tip line procedures, but they had refused to comply. So if there were, that's really hard to countenance under any process of accommodation. They didn't answer. When the DAG came up here, it was just mumbly peg, nothing happened. So if they knew that I had a court to go to say, come on, Your Honor, please, this looks ridiculous. Can we formalize an accommodations process and have you supervise it until you're comfortable that both sides are acting in good faith? That seems to me to be a kind of sensible intermediate step, just for your references, you're mulling on this notion, which I will ask you to think more about and answer as a question for the record. Professor Muscat, you mentioned two things that you recommended. One, that when there's a subpoena or some other request for information, Congress should be clearer about what it wants and why it wants it, so it can jump over the legislative purpose hurdle. And I agree with those things, and we might want to, bake that into what we're doing. Then there's the question of misconduct, which in theory blows up executive privilege. Presumably at some point early on, if Congress is going to assert that misconduct is the purpose of our investigation, we need to let that be known and explained pretty early on so that anybody who's considering this, whether it's a court or OLC or whomever, can A, determine that the misconduct concern or allegation is real enough to justify it, and B, if that's the case, boom, there goes the privilege. Reactions?
Yes, Senator. First on the idea that the misconduct purpose is absolute. I do think the court has acknowledged that, even where there are concerns of misconduct, that there are certain kinds of information like classified information, national security, and foreign affairs concerns that still might come into play. So I don't know that it's 100% absolute. I do acknowledge that it's a concern. And I guess what I would say though is I'm not sure that even the Congress has been authorized constitutionally just with general blanket investigative power. So even I think in the area of misconduct investigations, there would still presumably be a particular law or legal requirement that Congress had felt was broken and needed to see if it needed to be addressed, complied with more adequately, fixed in the legislative process, and that in explaining the need for documents, there would need to be some tie back to legislation. Alternatively, of course, the constitutional process for investigation is impeachment, and so I know, there were obviously conflicts over wanting to get information in recent history. And, the rules of the road change, of course, once the House would have authorized, impeachment inquiry. But that is really the constitutional method to go through for just pure misconduct claims. And so once such an inquiry were started, of course, there'd be different rules than if Congress were just acting out of its legislative power. If I could just say, make a couple of quick comments about the judicial question. The senators are obviously correct that in Marbury, there's discussion about the courts having a role in determining constitutionality, what the law is. But the Article 3 power, I think, distinct from the Article 1 and Article 2 powers, is just limited to resolving cases and controversies. So when we're thinking about judicial process, there are all kinds of questions, I think, that would not maybe be adequately addressed by just having a new judicial commission to look at oversight. One is there's got to be a limited case and controversy. Someone has to have standing to bring the claim. What would the judicially manageable standards be if the Constitution doesn't address information acquisition specifically? And then stepping back even further, we have talked about today, and the Supreme Court agrees, that as part of the legislative function, Congress needs information. But I feel like we're starting from an assumption that necessarily, we should just have access to all executive branch information at all times. And obviously, every branch has an interest in
I'm not, just for the
confidentiality.
record.
Okay. Well, every branch has an interest in confidentiality. Of course, legislative staff, committee staff, things like that. So I don't, when we're talking about information, again, I think it needs to always be tied back to what is the legislation that we're trying to put forward. If there are concerns about the executive branch having too much authority, it's much better to handle that through legislation that specifically guides and constrains what folks can do, rather than what I'm concerned about on the back end is giving power to the executive and then in a way that's not intended by the Constitution, sort of interfering with or questioning how it's executed. I think it's better to just give limited power in the first place rather than to interrupt the confidentiality and candor in advice giving that's really essential for the executive to get good advice once the power's been given.
Yeah, and the interesting thing about pretty much everything you've said is that's all stuff that courts have told us is the law. So that puts us right back to courts again, as far as I can tell. Senator Hono, do you want to continue? We're down to the two of us. We've got a terrific panel and an interesting question, so have at it.
I know, I feel as though we should make use of all these brains sitting in front of us. One description is that, and I think this is something that Professor Mascott pointed out, that Congress should need to show, let's say we're in court, that there is a legitimate legislative purpose for the information we seek. And so let's assume that the Congress shows that. Does that shift the burden to the executive to show that they can withhold the information? They have to do more than just say, well, we're exerting executive privilege. They have to show us why the burden shifts. Is that what should be happening?
Well, I think so the executive branch in a January 2021 opinion talked a little bit about this process, and that the threshold jurisdictional thing that the executive's going to look at first is the legitimate legislative purpose and looking for whether it's narrowly tailored to the stated objectives. And the Supreme Court also addresses this a little bit in the Mazars decision, that it needs to be narrowly tailored, not just a roving broad request. But yes, presuming that the request is tailored toward legislation, then adjunct to Congress's legislative powers, I think the general assumption would be that the executive branch then needs to carefully respond. And so, what happens as a matter of practice is often the accommodation process begins or executive privilege is asserted. But that happens in relatively rare occasions. And once that process is invoked, of course, the executive would explain reasons, as it often does through letters and other statements to Congress about why it's not handing over the information.
I think it's that part that the process that I'm interested in. When the burden shifts to the executive branch, they can't just simply say assert executive privilege. They have to show why they think that this information is it related to national security? What, right? They have to be very specific. Would you agree with that, Professor Shaw?
Yes, and I mean, just the way this works in practice is, so assuming that the threshold, I'm not sure I fully subscribe, well, I'll say I don't fully subscribe to the general overview in the January 2021 OLC memo that suggests a pretty rigorous kind of threshold determination of the legitimacy of legislative purpose. I'm not sure that's an appropriate inquiry for the executive branch to be engaging in, but assuming whatever that inquiry looks like, there is a legitimate legislative purpose everyone believes is satisfied. Generally speaking, so say there are 1,000 documents that are in the category that have been requested, the executive branch will take a look and say, of these 1,000, maybe 900 of them are completely uncontroversial, and we'll hand those over now. As to 100 of them, they may reflect internal deliberations, potentially even advice to or discussions about advising the president. And so we're going to need to engage in a process with you in which we'll ask you a little bit more specifically about the nature of your interest, and we can negotiate down from that 1,000 documents to 10 documents, and potentially at the end of the day we will need to assert executive privilege over those 10 if pressed, but hopefully we won't be pressed because you'll be able to get the information that you need based on reviewing the rest of the document. So I would say that would be the process that would typically proceed once the threshold determination has been made and it is determined there is some privilege material in the larger set of documents that are being requested.
So are you saying that in that process where you're arguing over the 100 documents that executive privilege may apply to, that is not being overseen by a court?
Typically not, no. So it'll just be between, at the staff level, potentially at the member level and the principals level in the executive branch, that sort of narrowing and winnowing occurs. And yes, it often does happen, again, in the shadow of these judicial opinions that sort of structure the process, but often without involving any court at all. And very often, at least until the last couple of years, the process has actually, to my mind, worked relatively well. Each side has been a little unhappy at the end of the day, but has gotten most of what it views as really important.
Yeah, I think we all agree that the accommodation process should be the first way that we do this, but we're here because what happens when that process is not proceeding in good faith. Thank you, Mr. Chairman.
Thanks. And if I could just turn this for a moment, we've been looking at this as the courts, if they have a role in this, making substantive determinations. But one of the things that strikes me is that part of what goes awry in these disputes often is not substantive disagreement, but process simply not happening. We have been treated, particularly in this committee, to so many non-assertion assertions of the privilege that it seems that the process is very much broken down. And my understanding is that it's supposed to be only in compelling circumstances that the assertion is made. There's got to be a careful review. It starts in the agency, but OLC has to come right in and offer its own, for want of a better word, ombudsman view, and then go through White House counsel to the president to say, Mr. President, this is important enough. We actually want you to assert executive privilege here. And unless and until the president does, there isn't a proper assertion of the privilege. There's only the abeyance moment awaiting the proper assertion of the privilege. So it would seem to me that it would be really easy for a judge or a panel of judges looking at this to go through the checklist of, okay, agency did a compelling review, OLC has been involved, White House counsel is involved, oh, and the president has asserted the privilege. Great, okay, now we can get to this. But if those things have not been done and the thing has jammed up just with an agency asserting a privilege without the OLC yet offering its opinion, without the White House counsel yet being involved, you're just like a stopper right there at the agency. We're not answering your question, go pound sand. That's a pretty easy one for a court to break through without having to intervene in challenging ways in the larger political process, because somebody's clearly playing outside the foul lines on process. And if we could get the process enforced, I think that smooths out a lot of these other things. Roselle.
Just one point, I find that you may end up in a challenging situation where, under those circumstances, presidents would simply avoid at all costs using the words executive privilege and resorting to other rationales for
Document stamped constitutional privilege, but
Right.
they didn't want to say executive
Well,
privilege.
you know, there is a long history of that, right? Particularly in the early post-Watergate era, when executive privilege had a bad name. Presidents avoided the use of the phrase executive privilege because they knew it was politically toxic, but they still wanted all the advantages.
That's the case
right?
still? Doesn't seem like it's the case any longer.
I think the embarrassment over the phrase executive privilege is not as great as it was
Yeah.
during that period, for sure. But if you establish a process by which the courts are going to be involved, right, and anytime the president utters the words executive privilege, there's going to be this intervening process to try to solve these disputes. I think that gives an incentive for presidents to simply, once again, start avoiding the use of the phrase executive privilege and resort to other rationales for withholding information, which ultimately, is a kind of, playing word games in a sense,
Yeah.
in order to get around the process that you would like to see put in place, I assume.
Although I would say that the president doesn't get to not give Congress information
Right,
for no stated reason.
right. Well, I agree with
Say
that.
law enforcement matters. You can say, grand jury matters. You can say national security matters. We can say too classified for you, or too much danger of improper release. And we've got the whole deliberative process, executive privilege nexus of ideas. And you can kind of call it what you want, but I think at the end of the day, no, and I'm not saying why, isn't an answer that should survive any kind of scrutiny or contest. Professor Schaub, you go ahead, and then I'll let you all go unless Professor Hono has other questions.
Just to
many
sort of
professors.
follow up on the
Professor too.
the process in terms of what actually happens within the executive branch. I think your sort of retelling of it is mostly accurate, but what happens at the first stage is more of, here's a broad request for information. Let's let the agency, the Council of Legislative Affairs, will look and kind of see what's there. And if there are items that are deliberative or law enforcement related, then a letter goes back to the committee that says, on some time frame, there are certain confidentiality interests here. And that's it. And unless the committee follows up on that or presses, there probably won't be any more communication or any more even look at the documents. And it's only when there's a press that it goes up to sort of OLC and you start to look and say, are these within the components? But the inquiry is now sort of, are they within the components? Can we withhold it? As opposed to, is this a very specific information that's going to cause some harm to the national interest? So it's sort of categories of undifferentiated confidentiality interest as opposed to sort of problems from specific information. And executive privilege is never even considered or discussed within the executive branch until the committee says or schedules a contempt vote. It's not, executive branch policy is not to assert privilege until immediately before a contempt vote has been scheduled. So it's way down the road. And everything before that is just consideration of, is this permissibly withheld? And we'll decide whether to withhold it or not if they schedule a contempt vote.
We have, I think, room for considerable improvement in the way in which these conflicts are managed. And I, for one, hope to find a way to make some improvements in a bipartisan fashion, perhaps by starting with a committee report that all the members of the committee could get behind that lays out some of the ideas. So I hope you don't mind if we stay in touch with you as we continue to develop that. You've been a very helpful panel, and I'm grateful to you all for being here. And if you could take under advisement my notion, I don't want to even call it anything more than that, that if there were a calendar over at the district court, and if a dispute got to a certain stage, and we'd have to figure out what the trigger was, it was allowed to go on that calendar. And when it got on the calendar, there'd have to be some regular meetings of some kind, not to settle the law or make final dispositive determinations, but to say, how are you guys doing at your process of accommodation, and to give each party a chance to blow foul on, well, we haven't even had an answer. And this seems pretty obvious. It's actually public information somewhere, I think. I think that could move things along. Again, my history here is that status conferences work pretty well at rattling the cages of parties and cut through tons of the discovery disputes and real litigation. I mean, you really don't want to annoy a judge by having to have them constantly rule on discovery disputes. And in a lot of status conferences, there is no formal ruling. The judge or the magistrate just says, "Are you out of your mind? Do you really want to bring that notion to me formally? How do you think that's going to turn out? Have you read this case?" And then the lawyer kind of gets abashed and says, "All right, well," goes back to the client and says, "All right, we probably have to give up this document." And it all happens again in an accommodations process. But it's a guided accommodations process, so nobody has the unilateral ability to bring it to an end in bad faith without recourse. So that's where I think we are. Thank you all very much. And what are we, a week to get? Would a week be okay to get your answers in? 2 weeks? What would you prefer?
That is fine.
Week's fine? We'll do a week. Thank you all.
Thank you.
Hearing adjourned.